did you want to comment on that, or did you have a separate objection?
We don't object, but I would just ask that in light of the timing with the rebuttal testimony and discovery related to it, that when OCA's witnesses come up, that the board give us latitude to do some additional questions to respond to things in the rebuttal.
Thank you. Mr. Leonard.
Thank you, Your Honor. First of all, when it comes to the rebuttal testimony, that's not rebutting live testimony that hasn't happened yet. That's responding to testimony that was pre-filed. That's how the board does it. That's how the board has always done it. The procedural order in this matter set a deadline for rebuttal testimony. We do not have an objection, as Mr. Long suggests, to them having some latitude to ask questions about that rebuttal testimony, given its timing. Second of all, with respect to the particular issue that Mr. Jorde pointed out and objected on hearsay and foundation grounds, I think it's well established that in agency proceedings in Iowa, including before the board, that hearsay is not an adequate objection, that evidentiary standards are relaxed, and we therefore urge the board to admit the written testimony, both the direct and the rebuttal.
So I need to respond to that. On the rebuttal, again, until a witness shows up and is tendered, their testimony doesn't come in, just like Mr. Powell here. So again, you can't rebut something that has not occurred, is not in evidence, is not part of the official record. The rebuttal cannot come in at this time.
Thank you. Mr. Long, did you have additional comment? Okay. Thank you. Mr. Lynn? Okay. Any other comments? Okay. Thank you. Mr. Jorde, your objection is noted but overruled. Both direct and rebuttal testimony will be admitted. Mr. Blinsky? Or Mr. Leonard? Sorry.
Thank you, Your Honor. We now tender the witness for cross.
Thank you. Rather than go down the list, I think we'll just go ahead and proceed as we have with the placards flipped on their side. So I see Mr. Jorde was first, and so we will start with Mr. Jorde.
Great, thank you. Sir, who is Summit Carbon Solutions, LLC? Who are its owners?
Its owners are private investors.
And who are they?
There are several hundred, to my knowledge, several hundred of private investors. So I'm not aware of all of those individuals.
Who would know who the owners are?
Again, sir, it's not me.
Okay, well, is anyone going to testify so that we have evidence on who actually is behind this proposed project?
Not to my knowledge.
All right, and so then you would agree that it's impossible for the IUB to approve this application if they don't even know who the applicant is, correct?
I would not agree.
In terms of the South Korean entity that owns 10%, you're aware that they are an investor, is that correct?
I am aware.
And you're aware of one of their subsidiaries was fined nearly $50 million by the U.S. government for fraud. Are you aware of that?
I'm not aware of the details.
Okay. And are you, do you personally have any ownership in the applicant or any entity that has ownership interest in the applicant?
I have equity in the business.
And in terms of equity, would it be true that the entire management team of Summit Carbon Solutions has equity in the business?
I'm not aware of the compensation packages for other members of the management team.
Well, without getting into the specifics, you're aware, are you not, that other members of the management team have equity, regardless of how little or how much, correct?
I'm not going to make an assumption. I'm not aware of their individual compensation packages.
All right, so I would need to ask that question individually to all the Summit witnesses that testify then.
Sounds prudent to me.
And in terms of the South Korean entity, what other direct or indirect foreign ownership that is outside of the United States entities or persons have any ownership in Summit Carbon Solutions, LLC?
I'm not aware of any.
And again, is your testimony the same, that no one is going to be presented to this board to testify as to the ownership structure in any foreign investment?
Not that I'm aware of.
And is there a particular reason why Summit is concealing the identity of who's behind the entity?
Object to form. Question assumes facts, not in evidence.
Thank you. Mr. Jorde?
Well, they're not in evidence because he's refusing to tell us, and so that's the basis of the question. Why are you not sharing this information?
Well, again, Mr. Jorde, I'm not aware of every investor in Summit Carbon.
Hold on, Mr. Powell. Mr. Leonard, did you have a response?
Just to the form of the question, his assumption that somebody's concealing something just because one witness doesn't know the identities of all the investors in the company, it's an improper question.
Okay, thank you. The objection is sustained. Please reword your question or move on, Mr. Jorde.
Certainly. So do you know why Summit has chosen to not disclose that information in terms of who are the owners?
That's a private investment. I'm not part of that decision-making process.
And this project, of course, the purpose of the project is to generate profits for Summit Carbon Solutions LLC, correct?
Well, like most businesses, the objective is to generate a profit, correct?
And as between an analysis of whether or not this board should allow Summit Carbon Solutions to generate a profit or target the properties of Iowans, you would agree that on balance, the interest of Iowans should win out over your profits, right?
I don't understand the question.
Well, if we're doing a balancing analysis as between your proposed project, which is, as you just admitted, for the profit of applicant, you would agree that, in effect, the tie should go to the runner here, which would be the Iowans that are opposed to this project.
Well, I think the benefits are more than just Summit Carbon. The benefits are to the ethanol plants, their workers, and the farmers who supply corn to those ethanol plants. It's the profitability of the ethanol plants that's at play here, as well as their contribution to the economies in their counties, their communities.
And did anyone, are you going to call a single witness that did a cost-benefit analysis of the net alleged benefits in regards to the costs to the landowners who do not want the project, or is your evidence only focused on the alleged good of the project?
And I don't understand the question.
So what is it you're asking this board to do? Are you not asking this board to grant your application, which would then allow applicant to profit, and then based on your last answer, 13 or so ethanol companies to profit? That's what you're asking for?
Again, we're asking the board to approve the project so we can help those ethanol plants and all those directly and indirectly affected by those ethanol plants remain profitable.
And do you think it's under the purview of this board to pick winners and losers and put the interest of a handful of ethanol plants above those of regular citizens?
Objection.
State your objection.
Calls for a legal conclusion as to the board's purview.
Mr. Jorde?
Well, okay, I can restate it. Are you asking this board to pick winners and losers and pick you and a handful of ethanol companies over the interests of those opposed to the project?
I'm not dictating what the board does or does not do.
You would believe it would be reasonable to consider first the existing landowners and people and farmers opposed to the project prior to considering your entity, a newly formed entity, and its interests, correct?
Well, Mr. Jorde, we've reached agreement with 73% of the landowners in this state, so we fully expect that we can reach agreement with the remaining landowners that'll be affected.
And you would agree that there's no such thing as a voluntary easement when the threat of eminent domain is hanging over a landowner's head, correct?
Well, Mr. Jorde, we've been negotiating with Iowa landowners for almost 2 years, and we have not had and still do not have the right of eminent domain.
Well, isn't it true in your initial letter that you mailed out to landowners, you mentioned the right or the pathway to eminent domain, and you did that in intent to scare them into signing easements?
It's my recollection that the IUB process is prescriptive as to what has to be included in those notifications to landowners.
Why did you sue Iowa landowners for survey access just to dismiss those cases?
We have to have access to properties to survey, and the process within Iowa allows us to do that with 10-day notification.
And so the question was, why did you sue Iowa landowners stating that you needed immediate access to their property just to later dismiss those lawsuits?
I don't recall the rationale.
Who makes the decisions at Summit Carbon Solutions LLC?
Regarding what?
Well, who's are you the top guy, so to speak? The buck stops with you, or is that Lee Blank, or who makes the strategic decisions?
Well, Mr. Blank is the CEO, but when it comes to the design, construction, and operation of the pipeline, I'm the decision maker.
What role does Bruce Rastetter have in Summit Carbon Solutions LLC?
He's an investor and a board member.
And is it true he was the original promoter of the project?
Well, Summit Ag, they developed the concept for the project.
And Summit Ag being one of Mr. Rastetter's entities?
I'm not familiar with Mr. Rastetter's portfolio, but yes, he is the CEO of Summit Ag.
And who was it Summit Ag's concept? Was Summit Carbon Solutions LLC something that was born out of Summit Ag?
Yes.
And why is it that Mr. Rastetter isn't here to testify and defend the supposed value of this project?
I think he entrusts his management team to defend the value of the project.
And so by that answer, would you agree that you essentially work for him when you reference his management team?
No, I work for the board of directors, in which he is one member of.
Who are the rest of the directors?
There's members from Tiger Infrastructure, from TPG, from SK, and from Continental Resources, as well as Summit Ag.
And Continental Resources, that's owned by Harold Ham, is that correct?
I believe that is a correct statement. They just took that company back private.
And Mr. Ham has substantial interests in North Dakota, does he not?
Yes, he does.
And then TPG and Tiger, those are investment funds or hedge funds that have many foreign investors, is that correct?
I'm not familiar with the makeup of their investors.
What about the assets of Summit Carbon Solutions LLC? Does it have assets, or are the owners on standby for equity to be called in terms of when it needs to raise capital to fund its business?
Well, we have assets that have been manufactured over the last 2 years, and we do have equity that's available.
Well, is it true the only asset of Summit Carbon Solutions would be the easements it holds?
That's not true.
What are the other assets?
We have various pieces of equipment that has been manufactured or produced.
And by that statement, do you mean the carbon capture equipment that you would intend to place at the site of any CO2 emitter that's in partnership with you?
That is part of it.
All right. What else? What other physical assets in terms of the equipment does Summit own?
We have components that will be installed in the pipeline system as well.
That Summit has already purchased?
Correct.
Were any of those manufactured in the state of Iowa?
Not that I'm aware of.
Has Summit filed tax returns?
In and I'm not the tax expert, Mr. Jorde. We do have a tax professional as part of the management team.
Okay, who's that person?
That is Joel, and his last name escapes me. We can provide that.
Okay. And it's Summit is a Delaware entity, correct? Incorporated in the state of Delaware?
That's my understanding.
Now, your particular role, you say you're responsible for technical development. Does that have anything to do with initial route consideration and selection?
It does.
And it's true that in designing the initial route, that was done based on what's known as desktop analysis.
I think that's a loose description.
Well, it's true that the initial route that you submitted in this docket was done before conclusion of all surveys on the land that you're targeting in this case, correct?
Yeah, Mr. Jorde, you have to have a preliminary route before you can determine where you want to survey. That is correct.
And as your statement is, in your direct statement at least, that typically the initial route is the most direct from point to point. Is that correct?
Typically with pipelines, it is A to B. However, the program that we use, the GIS-based program, that literally has hundreds of features, all publicly available information and some confidential information. And so we use that to develop the preliminary route.
And who is the provider of that software or that program, that GIS program you mentioned?
The program is called Pivot, and it's owned by a company called Terracon.
And it's true that Summit initially consulted with Terracon, and Terracon used its software and came up with the initial route. Is that right?
It was a collaborative effort, yes.
And it's true that when that process was occurring, neither Terracon nor Summit had future land use maps or master plans of the various counties or communities which it intends to locate its hazardous pipeline through.
That is not true.
Give me the name of the person who had any future land use map or master plan of any community that it was utilized prior to selecting the initial route.
Again, if a county or municipality had a development plan that was available, and typically online, then that was incorporated.
And who would be the person, unless, sir, did you personally do that work?
I did not.
Okay, who would be the person that could back up that statement?
Kent Strasser is the primary contact at Pivot, but Eric Skubinik, who's part of the Summit organization, may be able to answer that question.
And is that because Mr. Skubinik had more detailed interactions relative to the foundational basis for the initial route than yourself?
That's fair.
Okay. Is it true that you being Summit, did not utilize dispersion modeling or CO2 dispersion analysis or plume modeling prior to coming up with your initial route?
That is correct, because dispersion modeling is not used for routing purposes.
Well, it certainly could be. It's just that Summit chose not to use it for routing purposes.
No, that's not the value of dispersion modeling, so I disagree.
Okay. Well, do you think a community might find value in knowing how hazardous and dangerous a potential leak or rupture would be to them, and would want to know how far they are located from your proposed route?
Well, Mr. Jorde, you and I have talked about this before, so you know that PHMSA requires any operator, and obviously Summit, to perform dispersion modeling to determine what impact your route or your pipeline operation may have on a high consequence area. And so that's what we've done. We take that dispersion modeling, we take the outputs, and we put them in a risk assessment. That determines the probability and potential severity of any impact. And in Iowa, of the 686 miles of pipeline proposed, there are 1.13 miles of direct impact to high consequence areas in a worst case release scenario. That's 0.002%, if my math is correct.
And do you know what county, or are those 1.3 miles in multiple counties?
I'd have to refresh to look at the model output.
Okay, so then let's break down your prior answer. So first of all, you talked about PHMSA, and you're aware that PHMSA sets minimum standards, correct?
They set standards and incorporate by reference other standards such as API.
But Summit isn't prevented from doing better than minimum federal standards, are they?
No, and we've exceeded those standards in many, many areas, including dispersion modeling.
Well, no one would know that because to date you've refused to produce that modeling in Iowa, haven't you?
Well, as PHMSA recommends, that the output of that model and the risk assessment should be protected and not provided to the public.
Well, isn't it true on August 31st you produced that information, dispersion modeling, in the South Dakota PUC docket?
We did in confidence, yes.
All right, so you would therefore agree that you would produce it in confidence to this board today?
If the board would like to see that output in confidence, absolutely.
Okay, well, so it wasn't good enough for the Iowans that have been asking for it in discovery and had to take depositions and were rebuffed and had to go to court. That wasn't enough for you to think it might be reasonable to release the dispersion modeling?
Again, Mr. Jorde, the federal government thinks it's a bad idea to release that. And if you're going to build a home, you may be able to do it without a blueprint, but you could probably do a better job with a blueprint. So PHMSA and the federal government don't think it's a good idea to release that information, and someone with criminal intent could use it to impact public safety.
All right, so you didn't say it, but you're relying on this theory that, my goodness, if we released the dispersion modeling, some terrorists could get their hands on it and then we'd all be unsafe. Is that the gist of your response?
Well, it's not a theory.
And so we can take from that these pipelines are so dangerous, they are a threat to national security, and you would agree they have no place in the state of Iowa.
No, I just said that could potentially be a threat to public safety.
Do you think terrorists are so inept that they aren't able to determine where this proposed pipeline would be located based on the detailed aerial maps you've already produced in this docket?
Well, the resolution of those maps, it would be difficult. General area, perhaps. But again, Mr. Jorde, why should we make it easy for somebody with criminal intent?
Well, let me ask you this, sir. Have you been on the phone with the Pentagon recently about your route?
No, I missed that call, apparently.
Okay, well, I think everyone did, because it didn't happen, because this terrorist idea is complete nonsense, correct?
No, nobody mentioned terrorists, Mr. Jorde.
Objection.
State your objection.
I'm going to object to the form of the question.
Thank you. Mr. Jorde, go ahead and reword and move on.
Certainly. The fact of the matter is, this concept of these being dangerous to some type of an attack is just subterfuge to get around the fact that these are incredibly dangerous pipelines and you don't want the public to know.
Objection.
State your objection.
Same objection. It's argumentative.
Sustained. Mr. Jorde, please proceed.
So South Dakota deserves better than Iowa, right? Because you haven't produced the dispersion modeling in Iowa, right?
Didn't say that at all.
Okay. Well, the South Dakota PUC didn't ask you for it. They didn't have to ask you for it. You produced it in response to what happened in the Navigator docket up there, correct?
That's not true. The staff from the South Dakota PUC requested that information, not only the model output, but the risk assessment months ago,
Okay.
as you're aware.
All right. And you just got it to them on the 31st of August, right?
No. Again, they've had, you're conflating issues. There's a difference between maps with buffer zones and the model and the risk assessment.
I completely agree. There's three different things, and you've produced all of those things in South Dakota and none of those things in Iowa, correct?
To this point, yes.
All right, so won't you just do the right thing and agree to produce that today so the public here doesn't have to be in the dark?
Objection.
State your objection.
It hasn't been produced to the public in South Dakota for the reasons that Mr. Powell's been testifying about. It has been produced to the PUC.
Okay, thank you. Mr. Jorde, do you have a reply?
Well, the point is, this body that's charged with making an incredibly important decision does not have information they've voluntarily given another state. So what are we left to take from that? But for Iowa deserves less than South Dakota. And I just want him to be on the record right now and just say, you will release it. You have the power. You know you have the power to do that, Mr. Powell.
If I could respond.
Go ahead.
Obviously, dispersion analysis is something that's before the board on appeal on a motion to compel. It hasn't been ruled upon yet. If we're going to get into the details of that, we would wait for the board's ruling. I think I understood the chair's admonition this morning about that. In any event, if Mr. Jorde has a question he'd like to ask Mr. Powell as opposed to telling us what his point is, I'd be happy to have him ask a question.
Mr. Jorde, and Mr. Leonard, the objection is sustained. Mr. Jorde, the motion to compel is being ruled on, and we will hopefully have an answer shortly. Please contain your questions to facts, not speculation.
Okay. Well, again, I'm not speculating. I'm talking to exactly what has been done in other states. So, sir, you're relying on then the board to hopefully bail you out and say this information isn't something that should be produced to all of the folks here. Is that correct?
Well, Mr. Jorde, in my experience, which is extensive in this country building pipelines, I've never released a release or dispersion model in any service. And so this would be a first in this proceeding and in North Dakota and South Dakota. But again, if the board requests that information in confidence, yes, we will provide it.
Well, you would agree that it would be impossible to make a determination on public convenience and necessity if the full risk modeling that's available to you that you have in your possession and your lawyers is not made available to this board.
I would disagree.
Okay. So Summit's position is that the people of Iowa, the people being unwillingly targeted for this hazardous pipeline, they don't need to understand the risks. They don't need to see the risk mapped out as has been done in South Dakota, and that's not information you believe they need.
So, Jorde, I'm saying that there is a federal agency whose responsibility is to provide oversight and assurance for pipelines such as this. And so PHMSA doesn't even require the model. They may or may not ask for the output. They may or may not ask for the risk assessment.
And the reason PHMSA doesn't require the model is because PHMSA doesn't cite CO2 pipelines, correct?
Well, they are accountable for safety of regulated pipelines.
Sure, safety in terms of construction, operation standards, size of pipe, uniformity for interstate pipelines, but not for safety in terms of what does a state and locality, what they are potentially interested in terms of making county and statewide decisions. Would you agree with that?
Objection. Calls for a legal conclusion.
Mr. Jorde?
I don't see any legal conclusion there.
Okay, sustained. Please reword and move on.
Okay, well, I'll reword it. You would agree that siting of CO2 pipelines is left exclusively to the state, and in this case, the IUB, correct?
Same objection.
Well, okay, then what's the point of the application? What are you asking for in the application? I'll go the real slow route here. Let's go back to the application. What are you asking for?
We're asking for the Iowa Utility Board to grant us a permit to construct a pipeline.
In a specific location that you have produced maps before this board, which is called a route, which you need easements for, correct?
Correct.
All right, so you're asking this board to give you siting authority so you can locate your hazardous pipeline in Iowa, correct?
Correct.
All right, and that's because the federal government doesn't have jurisdiction over siting, routing, or locating hazardous pipelines, correct?
Same objection. Ask about the jurisdiction of the federal government with respect to pipelines.
The witness may answer if he knows, but we need to limit our questions to facts, not speculations or legal conclusions. But the witness may answer if he knows.
Can you repeat the question, please?
Well, yes, and the reason you're here is because you have to ask the state for guidance in order for the approval to site, because neither PHMSA nor the federal government has siting authority over CO2 pipelines, correct?
PHMSA has guidelines around siting with respect to setbacks, etc. But it's my understanding that the siting authority is with the Iowa Utility Board.
Okay, yeah, all right, see, thank you. So the IUB is here to site the pipeline, and now we're going back to where we started, and you would agree that an entity in charge of siting a pipeline, that it would be reasonable before siting a hazardous pipeline to have the risk modeling to consider. That would simply be reasonable. Can you agree with that part?
Well, I can't speculate as to what the board does or does not want or what they think they need or don't need. What I can tell you is PHMSA is accountable and provides oversight of disbursement modeling and risk assessment and its overall operational safety of a pipeline, including this pipeline.
Okay, and I'll agree with operational safety, but sir, we're talking about steps way before operation. We're talking about answering the question, where is, if anywhere, an intelligent location in the various counties you're targeting in Iowa to locate a pipeline? And you would agree that it would be reasonable when determining if your proposal is rational to have the full risk analysis prior to making that decision.
Mr. Jorde, you can't decouple the safety that's designed into the pipeline from the operational safety. So it has to be designed with inherent safety and constructed accordingly. And then it's likely that you can operate the pipeline safely.
Well, you're familiar with the concept of avoid, minimize, and mitigate, correct?
Not really.
Okay. Well, when you are thinking of developing a route for a hazardous pipeline, the first thing that you should do is see what HCAs or other sensitive areas can be avoided. And if you determine as the pipeline operator they can't be avoided, then you try to minimize impact, which sounded like where you were going with the integrity of the pipeline itself. And then if you can't minimize, you try to mitigate. Is that concept generally familiar to you?
Well, I guess you made that one up, but your logic makes sense. And that's why, as I mentioned earlier, we have direct impact on 1.13 miles of HCAs in the state of Iowa, which is extremely low. Most pipeline systems, depending on where they're constructed, have as many as 40 to 60%.
And that might sound good relative to HCA's high consequence areas until we determine that the federal government only identifies 4 categories of HCAs and they only update them every 10 years when a new census comes out, correct?
And those are pretty critical areas, highly populated areas, other populated areas, eco-sensitive areas, and navigable waterways, you're correct. But those highly populated and other populated areas, pretty critical.
And the federal HCAs don't take into account actually on the ground what's happening in terms of expansion, in terms of new businesses, in terms of rural residential housing or development. The HCAs don't take into account any of that, do they?
No, but we do. If that information is available, we try to avoid economic development.
And that's what Mr. Chauvinek is going to tell us about. Is that right?
Mr. Skuvenik.
Skuvenek. He can tell us about that.
Yes.
So you agree, you admit that you didn't have any dispersion analysis prior to your initial route. You state that you affect 1.3 miles of HCAs. And what have you done to reroute around those particular areas?
Well, I didn't admit we didn't have a dispersion analysis. What I said is you can't model dispersion if you don't have a route. So you can't put the cart in front of the horse.
Well, that's not at all true.
That is true.
Okay, well, let's talk about that. Pretend we don't have a route, but I know I have a pipeline that's going to transport CO2 at 2,183 PSIG. We're going to have 20-mile intervals. It's a 24-inch pipe. I can calculate the volumes. I can calculate a guillotine rupture. I can calculate the release rate, pounds per second. I can calculate the release direction. I can do all these things, and I can determine, in a worst-case scenario, using wind speed and terrain, how far a plume would travel regardless of whether it's Iowa or South Dakota or anywhere else, correct?
Well, if you want to be relatively inaccurate, I think the preferred option is to route around where you know those sensitive areas are to the extent possible.
Okay, and to the extent possible is actually something 100% in your control as the applicant, correct?
No.
Okay, someone is forcing you to choose the route that's before this board.
Well, in Iowa, one, the process with the IUB is we have to establish a notice corridor, and it is up to us to establish that. But in Iowa, we've rerouted the pipeline from initial concept to today 1,500 times, and many of those were due to survey results, avoiding cultural features, environmental, biological features, or landowner preference. And so that's why we update our model on a regular basis to make sure that we're accounting for the most current and accurate information.
And you would agree of those claimed 1,500 reroutes, those would be what are known as micro reroutes or small slight modifications typically on the parcel that you were already targeting, correct?
Typically, correct.
And the notice corridor, well, I guess I should ask this. Are you asking the IUB for an exact route which is indicated in the most recent aerial maps that you've uploaded for the route, or are you asking for the ability to route within the routing corridor or something else?
We're asking for the route as presented with the ability to relocate the pipeline within the permitted easement.
Okay, so I want to make sure we're clear. Are you stating that it's your belief if this project were approved, you would be getting approval of an exact route and only have the ability to move the pipe within the 50-foot permanent right-of-way that you seek?
That's my understanding, and unless the board gives us latitude to work with the landowner.
Okay, and that's kind of what I'm trying to figure out here of what you think is being potentially approved or disapproved. So do you believe that Summit has the ability to move the potential route anywhere within a given Exhibit H parcel?
No.
All right. But reading through testimony, it's at least your point of view that you're willing to work with landowners who would present preferences or potential reroutes of what you have requested at this stage, right?
Again, if we were given that latitude by the board, and we had no constraints from a survey perspective, yes, we would be willing to work with individual landowners.
Is it true that Summit has not presented the local first responders, EMS, and persons in the various counties you seek this to locate the hazardous pipeline, you have not presented them with any dispersion or risk analysis, correct?
Although we've met with every emergency management person in all 29 counties, it is very premature to discuss or present them any information at this point. However, we will present that and tactical response documents and perform drills with them, desktop drills, before the pipeline is placed in operation.
And you would agree there's no good reason to not share the risk analysis and information with those entities and first responders at this time, correct?
No, there is good reason.
Okay, what? Tell me.
It's 2 years before we're potentially in operation, Mr. Jorde. A lot of these voluntary fire departments have high turnover. And so as we get closer to construct, and while we're in construction, then we'll begin that process in earnest, which is best management practice.
So do you see any value or do you see no value in the concept that you would want to give all potentially interested and affected parties the very best information you have at this time?
I think with you give them information that is relevant and that is necessary to provide at this time.
And necessary is something solely determined by Summit Carbon Solutions, LLC, correct?
As long as we're compliant with PHMSA regulations around public awareness, emergency response, preparation, and any state requirements, yes.
You're aware, though, that PHMSA only requires an emergency response plan for the operator and that there's no PHMSA oversight as to whether counties or first responders want their own emergency response plan, correct?
Yeah, and I'm also aware that first responders typically go by the response guidebook or the orange book. That's their basis. And we'll work with them to go above and beyond PHMSA once again and provide tactical documents, tactical response plans along the entirety of the pipeline in Iowa. And those plans will be specific to the location that first responder, fire department, etc., have jurisdiction over, and they will have a very good understanding of what a response may look like.
And in terms of getting them comfortable and for any planning or budgeting purposes for equipment such as self-contained breathing apparatuses or electric vehicles or things the first responders might deem necessary, you would agree, in the spirit of going above and beyond PHMSA, that you should immediately release your dispersion analysis to all first responders in Iowa.
I would not agree.
Do you think the first responders are incapable of appreciating the risk that they would understand if you were to provide your risk and dispersion modeling to them?
No.
Okay. So given they can understand it, and given that it's clearly important, again, I ask you on behalf of Summit, you would agree to release that information to county first responders today.
Now, what I would say, there's an orderly process in development. And so there's been those preliminary conversations with all these first responder groups, and we've actually solicited equipment needs that they may have. So as this project matures, and as we hopefully get approved for construction and begin construction, then that process will be pushed in more robustly.
But they can only make decisions upon equipment and needs that they perceive based upon the best information they have. And if you're refusing to provide them with the best information, then they obviously can't tell you what their needs are, can they?
Mr. Jorde, I didn't say we're refusing. I said that in time we will provide the information, and that will be in plenty of time to provide any additional resources they may need. And we'll support them with additional resources they may need.
And if Summit has its way, in time means after we've got approval, now we'll go ahead and show you how dangerous this is, right?
Again, we'll provide information when the planning begins in more earnestly.
Okay. And you would agree that because planning hasn't begun in earnest, that this application should be denied because you're simply not ready to move forward as you should be, correct?
Not at all.
Okay. Are we able to pull up exhibits from the docket, and if so, should I direct that at somebody? Could we please try to pull up 506 that was uploaded this morning?
We've got it. They're pulling it up. It's just a rather large file, so we'll get it up.
In the meantime, I would move for the admission of I've uploaded as Exhibit 551 Mr. Powell's deposition. I understand there's no objection to that being offered, so I would offer Mr. Powell's deposition as evidence at this time.
That's correct. There's no objection to the admission of the deposition transcript.
Okay, there we go. Mr. Powell's deposition will be admitted, and I believe we have our exhibit up now.
Thank you so much. And maybe if you could just maybe hit the plus just once, or there we go. And maybe just scroll down and see if you wouldn't mind. Thank you. Now, sir, what I'm showing you here is a publicly available document of Navigator CO2 pipeline company that they recently produced in South Dakota. And you would agree with me, sir, that having the ability to see something like this, where the purple is showing the potential consequence area of a hazard level 2 consequence, that would be important for the public to have in mind, and even those landowners when negotiating with you to understand the risk that your project presents.
I would agree that that's important information for first responders to have.
Okay, and what about the people that, not just the ones that are going to come from 20 miles away, but the people that live right there? Is it important for them to have?
Again, you're not defining what this actually depicts.
Well, I'd be happy to go through that, but my question is, you would agree not just is dispersion and risk analysis and visualization, like an overlay we're looking at here, it's not only important for first responders, but it's important for the residents, the business owners within the hazard area, correct?
I would say what's important to the individuals in these areas is the risk assessment that's done and the actions that are taken to mitigate that risk and the probability of an occurrence and the severity of the impact if occurrence should happen, which is extremely low.
Okay, so I get it. You want to, I guess your pitch is that you, Summit, will construct, or your contractors will construct a pipeline, and it's going to be so safe that we don't really need to worry about this type of thing. Is that what you're saying?
I didn't say that at all. We worry about it, and that's why we're going above and beyond PHMSA minimal requirements, as you phrased it, in many areas, including our dispersant model. So what you don't see on this buffer, which I believe is 40,000 parts per million concentration, is overland flow. So what Summit has done is 2D terrain-aided overland flow, and PHMSA requires dispersant modeling and terrain-aided flow analysis for high consequence areas, which I've stated before is a very small percentage of Iowa. We've done that over the full extent of the pipeline in Iowa. And so the integrity management program, which again, FINSA requires is specific to HCAs, will apply for the full extent of the pipeline. So all those things will make, I believe, this pipeline one of the safest ever constructed.
And based on that overland flow and analysis you've done, do you believe the analysis you have is more precise than a model that did not use overland flow or 2D analysis?
Yes.
And therefore, you are confident that the analysis you have done is more accurate, and therefore another reason why it should be shared with the public, correct?
I agree it is more accurate, as your expert witness in South Dakota has attested to. But I do not believe that it should be shared. As I said before, it should be protected.
So what we're looking at here is modeling an 8-inch pipeline. And in Iowa, are you ranging from 6 to 24 inch, or is it from 8 to 24 inch?
6.
All right, so you go from 6 to 24 inch. Do you happen to know the proposed miles within Iowa of each diameter pipe?
I do not. Mr. Skuvinik can provide that detail.
Okay. All right, and so you're going up or proposing to go up to 24 inch in diameter, and I'm sure you're aware, sir, that this is showing a 8-inch lateral on the proposed navigator system in South Dakota, and they calculated a distance of 1,855 foot as a buffer from the center line going in both directions. Do you understand that to be what this exhibit shows?
I can't read that from here, but if that's what you say.
All right. Let's just assume that's true, because if you cared to zoom in, that number is in there. But let's just assume, for purposes of my question, that I don't know if you call them a competitor, but another proposed CO2 pipeline company has said that risk goes out on an 8-inch pipeline under certain conditions at least 1,855 foot. And so my question is, when looking at the volume and the amount of CO2 that could be released in an unintended event, that to get from 8 to 24, you don't just multiply by 3. Is that fair?
That's fair.
All right. And in fact, by virtue of the physics and the chemistry and how the molecules are compressed, that the volume in a 20-mile pipe, 24-inch pipe, from the volume in a 20-mile segment of an 8-inch pipe is greater than 3 times. Is that true?
I'll take your word for it, Mr. Jorde.
Well, I'm not the engineer. I'm just repeating things I've learned. But if from your engineering background you disagree, please tell me.
I don't disagree.
All right. And so therefore, would you agree that if the depiction we're looking at on the screen has an 1,855-foot buffer for an 8-inch pipeline, we know that the buffer for a 24-inch pipeline should be greater than 3 times, or 5,565 feet, correct?
That is not correct.
All right. Would you agree that a reasonable buffer for a 24-inch pipeline would be 3,000 feet from the center line of the pipe?
Mr. Jorde, I'm not going to speculate, and you're using a navigator model as your standard. I can't speak to the accuracy of this model. And I can't, and you're talking about 20-mile valve spacing. I'm assuming that's a could affect area, so the valves would probably be, if I'm looking at milepost numbers correctly, would be spaced closer than that. But anyway, in any event, I can't speculate as to what the situation may or may not be in any area when we're talking about speculating about flow rate and pressure and location.
And it would be much better to not speculate than to just tell us what your numbers show, correct?
I know we've been there several times this morning, Mr. Jorde, but I have all day.
I have all week.
If the board requests that information in confidence, we're happy to provide it.
Okay. All right. Well, I guess we'll see. So maybe I can potentially leave this topic. Just to be clear, you, sir, on behalf as the what's your title? You're the Chief Operating Officer?
Correct.
As the COO of Summit applicant, you are not willing to release your data that would inform us if, in fact, the risks of a 24-inch pipeline are 3,000 feet, 4,000 feet, 5,000 feet. You're not going to voluntarily do that today, are you?
Again, I agree with PHMSA in federal courts that this information should be protected. And we do have our disbursement modeling expert and our risk assessment expert that are slated for witnesses in this proceeding. So there'll be an opportunity to talk to subject matter experts in both areas.
Well, but I'm not asking for subject matter expert. I'm asking for the buck stops here, the Chief Operating Officer, to just say, yes, we are going to release this. Otherwise, I'm going to have the same dance with Mr. Godfrey and others.
It's not Mr. Godfrey I'm speaking of. However, I've said it multiple times this morning. I do not think we should release it publicly.
All right. Are you talking about Mr. Locke?
Mr. Luke.
Luke, and he's with Audubon Field Solutions?
Yes.
Okay. All right. And so he would be, let's just say hypothetically, before he testifies, the IUB says, yes, you have to release it. Then Mr. Luke would be the person that would be able to walk us through how they went about the calculations, the inputs, the outputs, and all of those things.
Correct.
All right. Now, I've looked through your testimony here, and it says that you're going to be able to give an overview of the purpose of the project. And I'm just curious, in a sentence or, as succinct as you can on behalf of Summit, what do you believe the purpose of this proposed hazardous pipeline in Iowa is?
The purpose is to help the ethanol plant partners that we have contracted with to capture their CO2 before it is emitted, transport it to North Dakota and sequester it subsurface, which will allow them to significantly reduce their carbon intensity, which will then give them access to low carbon fuel markets, hopefully sustain the livelihood of their businesses and the demand for corn in the communities in which they operate.
Okay, so is a more direct way of saying that you believe the purpose is to save the ethanol industry in Iowa?
I didn't use the word save. I said it's to allow them the flexibility to sell in other markets, especially low carbon markets, that are more profitable.
And I'm going to pick up on that, but before I do, I don't want to forget to offer LO 506 that we were just looking at.
Are there any objections?
No objection from Summit.
Oh, and I probably need to add to that. So, Mr. Powell, were you aware that Exhibit 506, which again was part of the Public Utility Commission Navigator South Dakota docket, that despite what it says, it does not show a worst case analysis? Are you aware of any of that discussion that was held in South Dakota?
No.
All right. So then let's go back. Thank you for that. Let's go back to your last answer, which was the purpose of the project, and kind of break that down.
Mr. Jorde?
Yes, sir.
Are you done with your questions so we can admit that?
Good idea.
Thank you. The board will admit the exhibit as Jorde Landowners Hearing Exhibit 506.
Thank you.
Thank you. Go ahead.
All right. So back to the the summit stated purpose of the project. You mentioned North Dakota, and it's true that in North Dakota, the PSC of North Dakota PSC in a vote of 3-0 unanimously decided to deny Summit's North Dakota pipeline application. Correct?
Correct.
All right. And on August 31st, Oliver County denied Summit's request for 2 injection wells, correct?
That's my understanding.
And you would agree that it's not reasonable for this state and the folks here and all of us to be put through your application when you have no, you being Summit, have no place to go and have not a sufficient amount of storage capacity in North Dakota, correct?
Disagree.
In terms of accessing low carbon markets, sort of related to the low carbon fuel standard, you're referencing there California and Canada predominantly, is that right?
Yes.
And so your pitch here, why the purpose of this project is so that a handful of Iowa ethanol companies can end up potentially trucking or transporting via rail Iowa ethanol to California.
If that's their preference.
So you, of course, would say that pipelines are the safest and most efficient transportation, but you understand in order to access the markets, which is the basis of the purpose of your project, that the product, this alleged low carbon ethanol, would have to be trucked or otherwise transported not on pipeline to California and Canada.
It's being trucked somewhere now, Mr. Jorde.
Correct. So we don't need your pipeline, do we? Because what you propose to happen with the ethanol, it's already being delivered places, correct?
Well, I think that the amount of trucks that would take to transport 18 million tons of CO2 would be unmanageable.
Well, as of right now, according to your testimony, you're looking to transport 9.5 million metric tons per annum, correct?
Correct.
All right. And so do you think that it's in the public convenience and necessity of the citizens of Iowa to essentially take one for the team so that Californians can have a few years of low carbon ethanol?
I don't know what you mean by the term take one for the team, but I will say that we think this project will, or confident this project will help the ethanol plants in Iowa that we have contracted with to compete in the low carbon fuel markets.
And you would agree that the economic gain or economic benefit of your contracted ethanol plants is not sufficient to justify an approval of this project by this board, correct?
I would not. I mean, look at Dakota Access or other pipelines that transport a commodity from, let's say, North Dakota to the Gulf Coast. We have contracts with 12 businesses in this state that contribute to their local economies, employ people locally, and contribute to the state GDP in a much bigger way than a pipeline that just transports product across the state.
How many people are employed by the 27% of Exhibit H landowners that you have not obtained easements for?
I have no idea.
What is the gross domestic product in terms of output that the 27% of the families and their farming operations contribute to the Iowa economy?
I'm not sure.
And in fact, no analysis has been done of that, and therefore you as applicant can't make the case that this project has any net benefits whatsoever, can you?
I don't agree.
You don't agree just because you don't like it, or you don't agree because you have some scientific facts or numbers to support your disagreement?
Well, you're speculating that we can't reach agreement with the remaining landowners.
Well, if you're saying reach an agreement means if you don't sign it, we'll take it from you in court and make you run up a bunch of legal fees, then maybe you can. But I'm talking about an actual voluntary exchange, and you would agree that you've had very few actual voluntary voluntarily signed easements, correct?
No, I would disagree.
And part of your theory on the ethanol plants that you're partnering with and the benefit is that you believe if your project goes through and CO2 is somehow captured and shipped up somewhere to North Dakota, that then the ethanol plants might be able to make more money selling and shipping their ethanol into California. Is that the gist of it?
Well, I think if they are more profitable, they being the ethanol plants, and then they have the ability to expand, and then their demand for corn increases. If I remember correctly, the demand for corn in Iowa currently is about 1.6 billion bushels, which produces about 4.5 billion gallons of ethanol. So as that increases, the demand increases. And it's my understanding also that in reducing these plants' CI score, that's about 2 cents a point below 50. And so that extrapolates into higher prices for corn.
Okay. And are you relying on the gentleman from Ernst & Young to back that up, or do you have an economist that's going to try to substantiate what you just laid out?
Well, Ernst & Young will substantiate the work we've done around the economic impact, or the purported economic impact. But I think our ethanol partners can substantiate the value to them and to potential farmers that sell their corn to the ethanol plants.
And one of the links you try to make, sir, is that if there's more demand for corn, then the corn prices will go up, and if corn prices go up, then that will underlie or support or help land prices in Iowa increase. Do you stand by those statements?
Well, again, I think that commodity prices hopefully will stay reasonably stable, and at least what I've learned in the last couple of years, that land prices in Iowa have went up substantially in the last few years. And so as long as the ethanol market stays robust and the corn demand stays high, I would think that would contribute to sustaining high land prices in Iowa.
And can you think of any other market factors that play into the price and the fluctuating price of a commodity such as corn other than ethanol demand?
There are others, I'm sure. I'm not an expert in the ag economy, but the demand for corn, I would think, would be a contributing factor, a significant factor.
And do you think if an ethanol plant is having to pay more for corn, its principal input, that's going to have a drag or a benefit on its bottom line?
Well, it depends on the back end of that equation, Mr. Jorde. So if they're securing higher pricing in low carbon fuel markets, I would think that would benefit their bottom line.
Of the 13 ethanol partners that Summit claims to have in Iowa, how many of those are corporate owned, or how many of those are locally owned co-ops?
Well, I think the project we have in front of this, the commission, is for 12 plants.
Okay.
And Mr. Peroli, our chief commercial officer, would be much better versed in how those plants are organized, what their ownership structure is, etc.
Would you agree that the price of corn and an increasing price of corn is materially detrimental to Summit's business?
No.
So you would disagree with the risks outlined in Summit's private placement memorandum, where it says increasing corn prices could adversely affect the results of operations and profitability of the operating company?
It could.
Okay. And could is the key word, because all of this is pure speculation in terms of land prices staying up, if corn prices this, if California and Canada that. Your entire premise of your application is based on speculation, correct?
Well, I would say it's not speculation that currently CO2 is being emitted into the atmosphere. So pulling that CO2 off of the ethanol plant's fermentation process and capturing it and transporting it to North Dakota before it reaches the atmosphere, that's currently happening. So no, I don't think it's speculation.
So, but that begs the question then, let's leave the alleged benefit to maybe a handful of ethanol companies in Iowa. Is one of your, also, I guess the pitch here, one of the purposes of the project is to help with global warming and climate change?
Summit doesn't take a position on climate change. Our primary drivers are to help the ethanol plants reduce their carbon intensity and help them be competitive in low carbon fuel markets, which in turn, as you just said, drives demand for corn and keeps land values high. And the fact that those emissions are being removed from the process before they're being emitted into the atmosphere. And so peak capacity, if you had 18 million tons of greenhouse gas emissions that aren't emitted, that's probably a benefit.
And so I need to pin you down, sir. Are you or are you not proposing to this board that an environmental benefit is one of the reasons you think they should approve this project? That you're somehow affecting for the better climate change or global warming on this planet?
As I just stated, there is an environmental benefit.
Okay. And are you wanting this board and their decision-making process to include that in one of the factors that they consider, that you believe your project will produce an environmental benefit?
I'm not going to recommend what the board does or does not consider. As I said, there is an environmental benefit, in my opinion, of removing those greenhouse gases from the process before they're emitted into the atmosphere.
So let's talk about that. You would agree that the IRS, for being able to receive the 45Q tax credits, only requires proof that CO2 is sequestered for a period of 3 years?
I am not familiar with that.
Well, are you aware if the 45Q tax credits have any tether or any requirement or prerequisite that CO2 must be permanently captured and permanently sequestered?
Yes.
All right. And it's true that the IRS does not have a requirement that the CO2 be forever captured in order for Summit to apply for and receive 45Q tax credits.
I am not aware of that. Again, Mr. Paroli would have a much deeper understanding of that than myself.
So you would agree that if in North Dakota, and Harold Hamm, who has various oil and gas interests, that one of your major investors, that in North Dakota, if someday in the future this CO2 is in fact used for EOR, enhanced oil recovery, which North Dakota has said they're desperate for CO2 to do that, you would agree that then any alleged environmental benefit you're asking this board to consider would be destroyed, and therefore they should not consider that?
I would disagree, because I know there are stringent requirements from the North Dakota Industrial Commission and the federal government around how the CO2 that is injected subsurface is measured, and the volume and size of the subsurface plume. And that's why we'll have monitoring devices at the surface and subsurface. And so we'll have to maintain that information, it's my understanding, for the life of the project.
That you'll have to maintain information, or it's your understanding that you actually have to prove that every metric ton of Iowa captured CO2 is still somewhere underground in North Dakota forever?
Prove. And a little, not a well-known fact, Mr. Jorde, to use CO2 for enhanced oil recovery, the oxygen content has to be very low. The oxygen content generally in this CO2 stream will be significantly larger. And so to actually use it for enhanced oil recovery would require a liquefaction facility that will be the largest in the world. So it's not feasible or practical at this time.
Can we take a look? And by the way, I'm just gonna keep going unless you cut me off for a break. So I'll just leave that up to you. Keep going. Okay. If we could please pull up Exhibit 571. Yeah, thank you. If you wouldn't mind maybe minimizing that somewhat so we might be able to see the very top there for a second. Thank you. Sir, are you aware of this article coming out, or these statements made by the North Dakota State Department of Mineral Resources in very close, within days of time of when the PSC, North Dakota PSC, rejected the summit application?
I am not.
But do you think it's a coincidence that within days of the PUC, which we can tell by the date of the article, PSC rejecting the summit application, that the North Dakota Department of Mineral Resources warns more CO2 is needed to sustain oil production long term? Do you think there's any connection with those things?
I do not.
And is it true in your North Dakota application that you don't specifically say you will never use the CO2, and you don't specifically commit to absolutely only sequestering the CO2 you intend to transport into North Dakota?
Incorrect. I mean, Mr. Jorde, we're a common carrier. So the ethanol plants that we've currently contracted with intend for us to transport that CO2 to North Dakota and sequester it, which will benefit them, as we previously discussed this morning. If another carrier decided to use or ask us to transport CO2 for another purpose, like enhanced oil recovery, then that's a possibility. But it would be segregated stream of CO2.
Okay, but let's just go with that. If it's a possibility that on the pipeline system that you are asking for approval here in an application that says you'll never do anything other than permanently sequester CO2, if it's a possibility that in fact you will use it for EOR, then this board cannot rely on any of your alleged environmental benefits, correct?
Mr. Jorde, as we've said many times this morning, the ethanol plants, the 12 that we're currently contracted with, intend for us to transport the CO2 that's captured and sequester it. That benefits their ability to compete in the low carbon fuel markets.
Well, the fact of the matter,
that's the scope of the project we have before the board.
The fact of the matter is that Summit is going to own the CO2 that it intends to transport on its pipeline, so you have no customers and you have no shipper because you are your own shipper, correct?
We are committing to transporting the CO2 that we do take possession of at the capture facility to North Dakota and sequester it.
All right, so you would agree that Summit is going, under the model in Iowa, is going to construct and own the carbon capture equipment that attaches to the ethanol plant and then attaches up to the proposed pipeline, correct?
Correct.
And then Summit will take title of the CO2 at the title transfer point, which is the point where the pipeline, the transportation pipeline, meets the carbon capture equipment.
Objection.
State your objection.
I'll object to the extent it calls for a legal conclusion as to where Summit takes title.
Mr. Jorde?
It's a factual question of where they take title, and the COO would certainly know what the business model is.
Okay. Witness may answer the question if you'd like.
Well, we actually take custody of the CO2 at the scrubber that comes off of the fermentation process at the ethanol plant. Mr. Paroli can talk about the commercial aspects of the CO2.
Okay, so your answer is that Summit does take title. Are you saying take title, or are you saying take custody? Are you differentiating between the concept of the title transfer point and the concept of taking custody?
I'm differentiating because I have not seen the agreements, the offtake agreements between the plants and our commercial team. But I do know we're take custody at that point, and that's in our care to compress it, dehydrate it, inject it into the pipeline, and transport it to North Dakota for injection subsurface.
And you would agree that if Summit in fact takes title, not just custody, but takes title to the CO2 molecules at the moment it enters its pipeline, that it is not a common carrier?
Objection.
Calls for legal conclusion.
Mr. Jorde.
He said he was a common carrier, and I'm trying to figure out what he meant by that.
You can answer if you know.
We're a common carrier because if someone can meet our quality specs and has a means to get the product onto the pipeline and has a location to get it off of the pipeline, and we have capacity, and we're maintaining 10% of the capacity of the pipeline for other shippers, then I believe we're a common carrier.
Well, okay, you have that belief, but if we really started to dig into that, would you agree Mr. Paroli is the more appropriate witness, or are you willing to field questions on everything you just said there?
Now, Mr. Paroli is our chief commercial officer. I think he's better suited to ask those questions.
Okay. So I guess I should offer Exhibit 571.
No objection.
No objections. Hearing no objections, the exhibit will be admitted as Jorde Landowners Hearing Exhibit 571.
Thank you. And I would also offer 570, which is the North Dakota PSC decision denying Summit's application.
Are there objections?
Just a moment, I'm trying to take a look at it. No objection.
Seeing no objections, I believe we already took judicial notice, but in an abundance of caution, we will admit as Jorde Landowners Hearing Exhibit 570.
Yep, I appreciate that, and now at least we have a copy as opposed to judicial notice. I don't know if it would be in the record, but I appreciate that clarification. Sir, on page 4 of your direct testimony, you state that that your intention is to plan, construct, and operate a world-class project which meets the needs of the shippers. And again, you are the shipper because you take ownership of the CO2 molecules, correct?
When I say meets the needs of the shippers, the intent in that comment is our customers. And in this case, currently, it's the ethanol providers, but could be others in the future.
Well, but they're not customers because they're not paying you for transport. In fact, they're just giving you the CO2. You become the owner, and then you ship it for yourself, correct?
Objection.
State your objection.
Same objection as previously. It calls for a legal conclusion. Also, to the extent this gets to the terms of the offtake agreements, it's more appropriate for closed session.
Thank you, Mr. Jorde.
Well, I guess I'll ask Mr. Powell this. In terms of the offtake agreement, sir, and getting into those, would Mr. Paroli be better suited than yourself for that discussion?
He would.
Okay, so I'll hold that. We'll wait for Mr. Paroli on that. Again, we talked about the 9.5 million metric tons per annum, and your statement is that when you look proposed project wide, that is the committed volume that you believe you have presently?
That is the committed volume we have presently, and about 3.3 of that is associated with the 12 Iowa ethanol plants.
3.3 million metric tons
Correct.
of that? Okay. And is, does the 9.5 million, based on how you'll calculate the tax credits, 45Q tax credits, does that put you at a break even annually? Does that make the project viable, that volume?
Again, I think that's a question better suited for Mr. Paroli.
You claim that CO2 is in a supercritical state, and you understand that supercritical is a different physical state that's not liquid. You understand that?
Well, I understand that supercritical has both liquid and gas properties.
So you would agree supercritical, by the very fact that we have a term supercritical, is different than substance or molecules in the liquid phase.
Again, I think it includes, well, I know it does, it includes both gas and, it's a fluid that includes both gas and liquid properties. And there will be times on this project, in the operation of this pipeline, when the liquid or the CO2 in this pipeline may drop below the supercritical temperature threshold, and it will become a liquid. And as PHMSA dictates in a pipeline system, if that occurs anywhere along the pipeline, then it applies to the entire pipeline.
Where specifically on your proposed route would that occur?
Again, you're asking me to speculate about the operation, time of year, discharge temperature, specific plants, etc.
Well, okay, I'm not asking you to speculate on the operation. You're the operational officer. I'm asking you to comment and defend the statement you just made that, according to you, the CO2 will be in a liquid phase at certain places. I just want to know where and when that can happen.
I said it may be in liquid state and at certain times of the operation.
All right, so it may not then be in liquid state in certain times, correct?
And that's why it says supercritical or dense phase.
All right, but dense phase is just industry jargon. That's not a scientific term, correct?
I disagree.
Okay. But in any event, supercritical defines a type of matter or a state of matter that is different from a liquid or gas, correct?
Objection.
State your objection.
I'm going to object to the extent called for a legal conclusion under Iowa law.
This witness is talking all about the different phases of matter. I think he can answer the question.
You may answer if you don't.
Could you restate, please, Mr. Jorde?
Yes, just simply, sir, so we can move on. But so supercritical defines a particular phase of matter that is different than a gaseous phase or a liquid phase, correct?
I would just say it is a fluid that has both liquid and gas properties.
All right, and a fluid isn't a state of matter. Fluid is a description of a substance, correct?
Yeah, again, it is a fluid that has gas and liquid properties.
All right, so it's neither one or the other, but according to you, supercritical has gas and liquid properties. Is that it?
Well, I disagree with your characterization. As I said, it has liquid and gas properties.
All right, but it's different, correct? I mean, we have a separate word to describe it because it's not the same, right? Supercritical and liquid are not the same. Can we agree on that?
They're not identical.
Okay, all right. And neither is supercritical and gas. They're not the same. They're not identical, correct?
Correct.
Okay. Now, you're aware of California and your low carbon fuel standard that they're phasing out internal combustion engines in about 10 years. You're aware of that?
Well, I believe that's a stated objective.
Okay.
considering the volume of electric vehicles or the quantity of electrical vehicles in this country and even on the West Coast, that's probably a challenge.
Well, wouldn't you agree that it would be better for us all just to get electric vehicles and skip this whole pipeline thing? Because that would really be the way to help the environment, wouldn't it?
I disagree.
And in terms of, I think you said if the board approves and all the other states approve, it would take you at least 2 years to become operational. Is that correct?
Potentially. Depends on when we receive those approvals and the construction window and whether we have to construct through one winter or 2 winter seasons.
And so let's just say, just for argument's sake, we'll pick 2 years. California is moving off the ICE standard in 10 years. That gives you about an 8-year runway, and you would agree that it's certainly not in the public convenience and necessity of Iowa to potentially have a handful of Iowa ethanol plants maybe make a bit of premium for 8 years in California.
Well, I wouldn't agree with that statement. What I would agree with is that globally and in this country, there's a push to decarbonize. There are many states, including Iowa, it's my understanding, that are looking at low carbon fuel standards. So, and again, Mr. Peroli can speak to this in more detail, but it's my understanding that it's our thought process that many other states in this country will adopt low carbon fuel standards and expand the market for these ethanol facilities. And then secondly, there are European markets for low carbon fuels as well. So I do not agree that the demand will diminish because California may or may not adopt a suite of electric vehicles.
So everything you just said is basically it's speculation. It's a hope and maybe and one day in Europe and maybe other states, but you don't have any hard evidence, and you're not expecting this board to rely upon the potential of Iowa somehow selling low carbon fuel to Europe as a reason to approve your project, are you?
Well, we do know what the demand is today for low carbon fuel markets, and if you're talking about a hope, I would think it's a hope if California thinks they'll have all electric vehicles by 2035.
Okay, is that a hope just as the low carbon fuel standard being around is a hope? I mean, they're both laws, aren't they?
Well, I do know that there's a demand on the West Coast and Canada now that's adequate to service the ethanol plants that we're contracted with.
So it would be a lot better, wouldn't it, just to try to build an ethanol pipeline rather than a CO2 pipeline? Just help these plants get to market quicker, safer. Would you agree?
Well, you've got to lower their carbon intensity to make their product viable for low carbon fuel markets.
And you would agree that if your pipeline is not approved and not constructed, that these same farmers are going to be able to take their grain to the same ethanol plants, and all the rest of us not in California are going to keep using ethanol, and everyone will be fine, right?
Well, not according to the Iowa Renewable Fuels Association, who indicated that if CCS isn't implemented, that the demand could reduce by as much as 75% and have an economic impact on this state of potentially $10 billion and on farmers of $1 billion.
And are you referring to the study that Mr. Rastetter asked to be done to promote this project?
I'm not familiar with what Mr. Rastetter did or not request. I just know what the study that was produced. I'm referencing the study produced by the Iowa Renewable Fuels Association.
And do you think they're a particularly neutral party in this debate we're having?
I can't speak to that, but I would hope they would be.
Okay. You don't think their members have any potential desire for approval of this project? You wouldn't count them as on your team, so to speak?
Again, I don't know what their stated charter is, but just from their name, Renewable Fuels, I'm assuming they would support a project like this.
All right, so in terms of again, the purpose, we've said global warming, although Summit doesn't take a position on that. We've said access to California, Canada, low carbon markets, and then you believe flowing from that access is higher corn prices here locally and then maybe that helps land prices. Is there any other alleged purpose of the project?
I think those are the primary objectives.
And you would agree that it's not the purview of this board to consider derivative or derivative on derivative objectives or potential benefits, such as if California low carbon, if increased corn basis, if increased land values. They don't go that far out when looking at this project for approval, do they?
Objection.
State your objection.
Calls for a legal conclusion as to the jurisdiction and purview of the board.
Okay, sustained. Mr. Jorde, can we reword, please?
Yes. Do you think, you talk a lot about ethanol, is this the ethanol board? I mean, who cares? What do you think ethanol has to do with whether or not a hazardous pipeline should or should not be approved in the state of Iowa?
I don't understand your question, Mr. Jorde.
All right. Well, I don't understand why we're talking about ethanol. I mean, can't this project, if this was a good project, couldn't it stand on its own and we wouldn't have to go if then, and all this speculation? It would just have a core purpose that we could agree is good. Wouldn't
Well,
that
Mr.
make more
Jorde,
sense?
you're apparently the only one that doesn't understand that. And as I've said, there's a robust market, not only on the West Coast, in California, but Washington and Canada. And the current demand is there for the ethanol plants that we're contracted with. And that demand, as you said, will be there for at least another 10 plus years. That assumes that no other demand appears. And then secondly, this project will definitely scientifically confirm that it will reduce the carbon intensities ethanol plants so they can significantly, so then they can compete in those low carbon fuel markets, gain higher value for their product.
Yeah, no, I understand that's the pitch here, but in terms of the balancing and the decision-making process, wouldn't you agree that it's not fair, it's not equitable, it's not publicly convenient, and certainly not necessary for you to get to that end to demand forever easements across Iowans' land, correct?
No.
All right. So Summit believes it can justify forever easements, the risk that you won't disclose because it's obviously so bad and so scary. You can justify all those things in the name of 12 ethanol companies' profits, correct?
As I've said many times already this morning, Mr. Jorde, it's not just those ethanol plants' profits, it's the people they employ directly and the indirect effects in those communities, as well as the folks that sell their feed product.
And if Summit was actually concerned about the effects on communities, you'd release your risk and dispersion data, right?
Disagree. And we are absolutely concerned about risk, and that's why we're going above and beyond PHMSA requirements in many, many areas to minimize the risk. And we've got an expert that'll testify in this proceeding that can speak in more detail to that quantitative risk assessment.
And to, again, test that stated concern, is there a single person in the state of Iowa not associated with Summit that has seen your risk analysis? Yes or no?
Well, as in the state of Iowa?
Yeah.
No.
Now, you talk on page 5 that the project is, quote, intended to provide, quote, expanded opportunities for ethanol and low carbon fuel markets, end quote. And again, these are all ideas. Maybe it happens, maybe it doesn't, but you can't point to anything concrete that you can solidly say will happen, will occur, right? This is all kind of betting on the come, this project, isn't it?
Mr. Jorde, no matter how many times you state that, it's still incorrect. There is a market for low carbon fuels that exist today.
Yeah, well, that wasn't my question. We can stipulate a market exists, but whether a single farmer or a single ethanol plant in Iowa actually benefits from the fact California has a market, you can't state that with certainty, can you?
Well, I can state with certainty that if they don't reduce their carbon intensity in some fashion, and this is by far the most significant opportunity to do that, that they cannot compete.
Well, that's not true. If we all just stayed as we are right now, the status quo would maintain and there would be no competition, right? We'll just say no pipelines, we're all the same, and we just carry on as we have for 100 years, right?
Well, as I stated earlier, Mr. Jorde, that there's a push for decarbonization. And so it's my understanding in meeting with these ethanol partners that they have a desire to be on the forefront of that push so they can ensure their competitiveness for their shareholders and their customers.
And again, I don't think I pinned you down on the makeup of the ethanol plants. Forgive me, but do you know which ones your partners are corporate owned, like a Poet, like a Valero, versus actual farmer owned? Do you know the breakdown of that?
You asked that earlier. Mr. Peroli would be the better person to answer that question.
Thank you. Now, in terms of the alleged economic benefits you discuss on page 6, do you believe Ernst & Young verified your economic analysis or your tax numbers in their report?
I believe they verified it initially, and now that we have a tax professional on board, they can, and as the project changes, or evolves, I should say, they continue to validate.
And that tax professional was a gentleman, you couldn't remember his last name, and he's not testifying, correct?
He is not, but Ernst & Young will testify, it's my understanding.
And your calculation of $30 million per year in ongoing property taxes, do you think the fact, regardless of what the number is, that you are going to follow the law and pay tax is a benefit, or isn't that something you just are supposed to do?
You're supposed to do.
All right. Now, you do talk about how the route for the pipeline was selected, and you and I talked a little bit about that. And it says here, including desktop analysis. Now, you wanted to talk that down, but it's right out of your own report, right? That desktop analysis was what you utilized?
Correct.
All right. Now, the above ground facilities, pump stations, have you determined how many there are going to be or would be if this were approved?
We have.
All right, and do you care to share that number?
Overall project, and Mr. Skubinik can confirm, overall project, I believe it's 7 in the initial scope, which would include this 9.5 million tons, and 16 to accommodate the 18 million tons. That changes somewhat periodically depending on the hydraulics analysis and the route changes, but I think that's current. But Mr. Skubinik can confirm.
And do you know, or Mr. Skubinik be best to answer, how far apart and the specific locations of the pump stations?
Mr. Skubinik can confirm.
Would that be the same for mainline valve placement and intervals?
Well, I can tell you that in Iowa there are approximately 100 mainline valves, and as I'm sure you know, we're the first major or large-scale project that will comply with PHMSA's rule on valve spacing. So the max spacing for mainline valves will be 20 miles.
Before I forget, are you familiar with the Bakken Energy's Great Plains Synfuels plant in North Dakota?
Generally.
All right. And it's true that that plant would be able to liquefy the CO2 such that it could be used for enhanced oil recovery, correct?
I'm not sure.
Is that something Mr. Ham's working on?
Again, I'm not sure. Continental Resources is a very large company. I'm not sure what their priorities are.
If we could take a look, and I see it's up there, if we could go to the top of page 8 of Mr. Powell's testimony, please. Okay, and so this is carrying over from the mainline valve discussion, and then it says there at the top, middle of the first sentence there, take into consideration the location of pump stations, semicolon, CO2 dispersion modeling, semicolon, in high consequence areas. So again, you're testifying here that you want this board, do you not, to accept the fact that you, Summit, consider dispersion modeling for the placement of your valves, but you're not sharing that information, right?
We did, and as I stated earlier, if the board requests that that information is provided, we'll comply.
All right. Let's talk about corrosion a little bit. You talk about the pipeline grade material will vary, and this is on the top of page 9 of your testimony, from API 5L X-52 up to X-70. Now, sir, are you familiar with the type of pipe that was used by Denbury in their pipeline that ruptured in Satartia?
Only as captured in the PHMSA investigation report.
And are you aware that you're stating you're going to use the similar type, grade, and specification of pipe as Denbury?
If I remember correctly, I thought theirs was a X80 pipe versus an X70.
Is your position X70 is superior?
Well, there is a difference in grade between X70 and X80, obviously. But I will add that we have completed a fracture control plan, and PHMSA has reviewed and accepted that plan.
Okay. And do you have any of the analysis of the fracture control plan, or the basis that led you to the plan, or do you have a copy of the plan that you're going to submit in evidence in these proceedings?
I have no problem submitting that plan in these proceedings.
Okay. So then, can I get your agreement that you will in fact direct your counsel to produce that to the rest of council here?
Objection.
State your objection.
This plan goes to the PHMSA preemption argument that's before the board with respect to the dispersion analysis. We maintain that it's preempted by PHMSA regulation, not appropriate for consideration, and not appropriate for dissemination to the general public.
Thank you, sustained. Go ahead, Mr. Jorde.
Okay. So even though you have no problem, apparently your lawyer has a problem with that. Did you get that?
Well, I'm not a lawyer, Mr. Jorde, so I'll defer to the best judgment of my attorneys.
All right. So we're not going to then be able to evaluate the worthiness of the project on the scientific and engineering basis. We're going to be left with the lack of evidence based on the legal objections. Is that fair?
Well, I guess again, you don't trust PHMSA as the body with oversight for safety and operation of the pipeline to validate or confirm whether the work that we've done, the technical work product we've generated, is adequate or not.
Well, okay. Does Summit, I guess, then therefore trust PHMSA and believe they're an organization that should be relied on? Is that what you're trying to say?
I think from a technical oversight perspective and from an organization that has generated minimum standards, yes.
And because PHMSA is an entity we should rely upon, this board should clearly hold off any decision in this case until they're done with their rulemaking related specifically to CO2 pipelines motivated primarily by the Satartia rupture, correct?
Not at all. As you know, the Satartia incident, as unfortunate as it was really a violation by Denbury of requirements that are already mandated by PHMSA in their current regulation. So PHMSA has ongoing rulemaking changes, or has considered rulemaking changes on an ongoing basis. So yes, It's my understanding that they are looking at potential changes on public awareness and emergency response. But if PHMSA were concerned about our project or any of the other projects currently under development, or the 5,300 miles of CO2 pipeline that's currently in operation in this country, they could take other steps to address that.
Well, are you in active role of advising PHMSA on the steps they should take?
I am not.
All right. You're aware that PHMSA held 2 days of meetings in this very state on this very topic, and are actively engaged in looking at changes to its standards and rules regulating governing CO2 pipelines?
I know they are evaluating their standards. As I said before, they are doing on a continual basis, and those, it's my understanding, are more specific as the CO2, is it segregated in its own standard, or does it remain in the liquid standard or the gas standard? But in any event, if PHMSA were to change their standards or requirements and make those retroactive, we would comply.
Well, are you or is someone better that you're going to call to testify on your behalf to get into what actually is grandfathered and what isn't under Part 195 and the PHMSA regulations? Are you familiar with that, or should we say that for someone else?
I'm generally familiar with it.
So if you're generally familiar with it, you are aware that certain elements are grandfathered, and that unless PHMSA were to change its many decades of regulations, that there would be nothing to do in terms of retrofitting the pipeline, because the pipeline would already be constructed prior to the new guidance coming out, correct?
Correct, but PHMSA requires us to maintain our risk assessment. And so any change in standard would potentially impact our quantitative risk assessment. And so then it's on the owner, and it's under the oversight of PHMSA to make sure that that risk profile has not changed.
Okay. Are you aware, sir, that the grandfather clause, so to speak, at 49 USC section 601-104 sub B exempts out the design, installation, construction, initial inspection, initial testing standards, that we don't get to go back and relook at that if you don't wait for PHMSA to update their guidelines? Are you aware of that?
I don't have it memorized, but I'll take your word for it.
And then before I forget, on that fraction propagation, are you aware that it's a single line, and it's Part 195.111 fracture propagation, and it states, quote, "A carbon dioxide pipeline system must be designed to mitigate the effects of fracture propagation, period," end quote. Do you understand that's the total sum substance of PHMSA's regulations on fracture propagation?
I do, but in their oversight role, that's why we've had technical meetings with their technical experts and our metallurgists, our consultants, and reviewed our fracture control plan in detail. And they had to be satisfied with the efforts we're making around material selection and construction.
But again, all of that is what your counsel won't let be released, correct?
Objection.
Argumentative. It's a fact.
Mr. Jorde, can you go ahead and restate that? Then I have a follow-up, a quick question for you. So,
Absolutely. So, again, sir, see what's so difficult, and I'll just say frustrating, is that you get up here, you say all these things, but yet we don't have the documents to question you on it. And when I ask you, to your credit, you said you'd release it, but then your counsel says, whoa, no, we're not. So how can this board, how can the public, how can we have any idea if what you're saying is true when you're not giving us the foundational documents to back up what you're saying?
Objection. Same objection also goes to the PHMSA preemption issue.
okay, thank you.
Well, how does it go to the PHMSA preemption issue? I mean, he's been talking about PHMSA all morning. What are we talking about?
Okay. If you know, you can answer. Otherwise, it's time to move on.